Hello. So, will your kids or grandkids or heirs, whoever you have, I'll just call them kids, will your kids inherit from you one day and then lose that inheritance as a result of a lawsuit? Probably not, but that's what we're going to talk about here today. All right. So, subject of our live stream: should you protect your children's inheritance from their future lawsuits? From the get go, I I really, even though my mind may think differently than others, there's really two categories of this protect from lawsuits discussion. This discussion is all about setting up your estate plan, leaving things to your children. And when I say your children, really I'm referring to your heirs. Your heirs could be children, could be grandchildren, could be nieces and nephews, could be unrelated people, but I'll just refer to your heirs as children because most people are leaving things. Most people who have children, and many people do, not not that there's anything wrong with not having children, but I'm just going to refer to leaving it to your children. But none of these rules are kind of children specific only, refers to your heirs. So, all right, so this is about this one way of thinking about this lawsuit or creditor protection is all about what can you do to set your children up so that their inheritance can't be taken by a creditor of theirs. I'm not going to be referring to the things that people do during their lifetime to protect their own assets from their own creditors. This is more about how can you set up your estate plan to protect it for your children or other heirs. And essentially, it's about balancing your desire to give your children or heirs the freedom to do what they want to with their inheritance versus putting restrictions on them in order to somehow protect it from future lawsuits that they might have. All right, so I want to break this down into really four parts. One, we've got what's all the fuss about this topic. Two, what's typical, what normally happens. Three, what's some of the reasons why people do leave an inheritance for their children in trust. And then we'll get really dig a little deeper into the creditor protection trust restrictions that must be in place to protect a child or heir's inheritance from their future creditors. Okay. As always, I see we've got some hellos. In fact, let me say hello to Larry Bald Eagle. That's a new one, and I like the American flag in the background. Joanne, appreciate you being on here and made it and on time. Fantastic. She can't stay. That's okay. Where's the emoji? And Ray, hello, Ray from Mississippi. Hey, neighbor. All right. So first, why all the fuss? I think when this topic does get discussed, usually, sometimes I'll ask people, why are you bringing up what if your children get sued? Are they going to lose their inheritance? And the response is usually like, Paul, every time I drive down the road, all I see is these lawyer billboards. Sue, sue, sue. The lawsuit doesn't cost anything. Everyone knows we live in a litigious society. People in America can sue anybody for anything. And so sometimes people say, I want to make sure my children are protected from this litigious society by making sure their inheritance is protected. So that's what this is about is number one, I'd say it's 2 points. Number one, should you do it? Do you think you should do it? And then number two, if you think you should, what's involved? And maybe you should answer one before the other. So, so again, we're talking about leaving things to children so that if they get sued or if they have a judgment against them, it's protected. On the other hand, sometimes when I do these YouTube live streams, I'll put out a little quick question on another platform, ask people's opinion. And one commenter on a platform, when I talked about this, leaving your estate in a way that it's protected from your children's future creditors, one commenter wrote, Paul, how many of your clients have ever lost everything they've had to a creditor? Good point. Doesn't happen often. In fact, if you've got 50 people live here, or if you're watching a recording, if you've ever lost significant assets as a result of a lawsuit, or maybe even know someone who did, and you're really privy to their circumstances, throw it in the chat. We'd love to hear about it. And that could substantiate, in some people's mind, why this is this is an important topic. Okay, so let me tell you though what's typical, and just this is kind of default estate planning 101, where there's zero creditor protection for the children. So 101 is someone dies without a will. Someone dies with a will, and in that will, they just say something like, when I die, or after me and my spouse die, or if my spouse predeceases me, I leave my assets to my children, or I leave 40% to person A, 40% to person B, and 20% to person C, or I leave the house to my daughter, and I leave the rest of my assets to my 3 children equally. So lots and lots of wills, lots and lots of living trust done exactly that way. And when I say kind of what's typical is just assets are left outright, whether that's to the children, whether that's to grandchildren, if they're adults, whether that's to other people that you leave an inheritance to. It's typical. I'm not saying typical is always right, but it's typical, or whether you leave assets through some type of TOD beneficiary on a stock or brokerage account, or a POD designation on bank accounts or credit union accounts, or you have IRAs or life insurance policies, and you just name individuals as beneficiaries. So that's really, really common. And when that's the case, assets, when they do pass along to your children or other heirs, they're going to be exposed to the creditors of your children. What does it mean that the assets are exposed to your children's creditors? So let's say, for example, your child is determined at fault and is in a terrible, automobile accident, or something happens, and there's a $10 million judgment against your child. Now, look, know there's a difference between someone filing a suit against your child and someone getting a judgment against your child. Those are two completely different things. Just because someone threatened your child with a lawsuit, or actually filed a lawsuit against your child, that doesn't mean your child is immediately liable for something. So, that lawsuit has to run through our justice system, and ultimately has to be, your child has to be deemed liable for there to actually be a liability. So, when we say assets are exposed to the creditors of your children, it means someone gets a judgment against your child, and now they're going to collect against the assets of your child. And some of those assets might be inherited assets, and if those assets are in your child's name, those assets may have to be used to pay the judgment. Now, adult children of yours are likely to have automobile liability insurance, homeowners insurance, and probably even have an umbrella policy. So the potential for losing is, generally speaking, only if a judgment exceeds those insurance limits, or there's a judgment rendered against your child for something they don't have insurance against. I will say, for example, there's some limited areas like your children's IRA accounts. I'm not talking about the inherited IRAs. I'm talking about the retirement accounts that they accumulate while they're working. Those retirement accounts are exempt in many states. If your children have cash value in a life insurance policy, that can be exempt. Some states exempt homes or a certain portion of the home as being exempt from creditors. So there's some exemption laws, and then there's people have liability insurance to cover some of these types of potential damages. But the general, what's typical is someone dies without a will, and assets are left to heirs. With a will, assets are left outright to heirs. Assets are left outright to heirs through TOD, POD designations, beneficiary designations, and those assets are exposed to the creditors of the children. Now, before I get into the really hairy stuff, let me go to the next phase when they're starting to put some protections in place instead of just leaving things outright to children or other heirs. So very, very common for, even though it's not the most typical scenario, the most typical scenario is just stuff is left outright to the kids or outright to the heirs, and they get it and it's subject to their creditors. They get it, it's theirs. They do whatever they want to with it. Some people do leave assets to their children in trust for a variety of reasons. If you have young beneficiaries, minors, grandchildren who are young, and you're going to leave them inheritance, or there's the potential that they could inherit while they're still young, you'll leave those assets into a trust. You never want to leave assets to a 6-year-old because they can't even inherit in their own name, and there'd have to be a guardianship proceeding at the courthouse just for a judge to appoint someone to be the guardian of that 6-year-old child, so then the guardian can inherit on behalf of the child. It's a mess. If you're going to leave things to young people, we always say leave it to them in a trust. Maybe if you are going to leave $50,000 to your grandchild, you leave it to them in a trust. Maybe name your child, the parent of that grandchild, as the trustee of that trust, and you put certain stipulations insofar as when that grandchild can have the money or what it can be used for prior to the termination of the trust when the assets are turned over to the grandchild. So that's common. Also common, and even getting more common, for parents to leave assets in trust for children to make those inherited assets more divorce-proof. The concern is you leave assets to your child either intentionally or unintentionally commingles the inherited assets with other community property or marital assets, and then the child gets divorced and they lose half of the inheritance. So sometimes parents will set up, I'd say it's really common for parents to set up these beneficiary controlled trusts. You leave $1 million to son Peter, and you leave it to the Peter Trust, and maybe even name Peter as the trustee. So you're not really restricting Peter from being able to do what he wants with the inheritance. But as long as those inherited assets remain in that trust the right way, they're not going to be commingled with other assets Peter may have with Peter's spouse. So if Peter does get divorced, he keeps his trust. Peter and spouse split the other assets. So that's common. Sometimes people leave assets in trust to protect those assets from the beneficiary. So very common for somebody to come to me on one of my Zoom calls that I have, and they'll say, Paul, we have a son. He's been in and out of substance abuse, facilities. He's doing pretty good now, but Paul, you just never know what might happen in the future. We want to set something up, they'll tell me, where we want to protect his inheritance from himself. And sometimes trusts are used to do that. And, where you leave assets to the Peter Trust, you name Fred as the trustee, so Peter can't access those trusts. Fred can access them and use them for Peter or make distributions to Peter. But the primary purpose of that trust is to protect Peter from himself. So there's lots of if my child gets sued reasons to leave assets in a trust for your child. And yes, people have asked, should that be a revocable trust or an irrevocable trust? It's kind of both. This may be set up so that while you're alive, your trust is revocable, and that's to avoid probate when you die. But when you die, your trust becomes irrevocable, and then assets will be transferred from your living trust to this Fred or Peter subtrust. And so that is irrevocable at the time of your death. So it's kind of a combination of revocable while you're alive, then irrevocable when you die. All right. So now let's get into the creditor protection trust restrictions scenario. So this is for those people who tell me, Paul, I have an adult child, and my child is responsible. I have all of the confidence in the world that my child is not going to blow the inheritance, and they've never been on drugs, and they don't get influenced by other people. So got a great responsible children. However, Paul, I'm concerned that if my child gets sued, successfully sued, once they inherit this money, this $1 million, this $500,000, this $200,000, this $7 million, I'm concerned that, their creditors may take it from them. What can we do? So, it's a complicated area, but I would say generally you're going to do two things. You can do a lot more than that, but the two that first come to mind are you're going to leave their inheritance in a trust for them, and you're going to appoint someone other than them as the trustee or a co-trustee of that trust. You'll also likely have what's called spendthrift provisions in that trust. Spendthrift provisions, they're designed so that creditors are barred from a beneficiary's interest in the trust. However, there's some limitations on how much protection a spendthrift trust provides. For example, I know in some states, beneficiary's interest in the trust may, in certain cases, be seized to cover things like alimony expenses, sometimes child support payments, or damages arising from a felony criminal offense committed by the beneficiary, or quite frankly, when just a court rules that a state's public policy is such that an exception is warranted, and a court allows a beneficiary's interest in a trust to be seized to satisfy some claim. All right, so the idea, though, behind appointing someone else as the trustee of a trust for children, this is where you're saying, I'm leaving, X dollars or X percent of my estate, or I'm leaving my estate to my children equally, or whatever that distribution schedule might be. This is where, how do I leave it so that, if after I pass away and they have this big trust, how do I make sure that nobody takes it from them because they got a judgment against them and a lawsuit against them? So again, there's some state law differences here, but generally speaking, if a beneficiary, if you leave $2 million to the Peter Trust, and as long as Peter cannot compel a trust distribution, because that trustee has absolute discretion whether, when, and how to make distributions, then the beneficiary has no property right that a creditor can reach. So, for example, let's say you're leaving $2 million to the Peter Trust, and you want it protected from Peter's future creditors. So you would be leaving that $2 million inheritance to what's called the Peter, I'll call it the Peter Spendthrift Trust, has all those spendthrift provisions. Peter can't sell his interest in the trust. He can't use it as collateral for a loan. And to the extent state law permits, no one can seize Peter's interest in the trust. And you designate someone else as the trustee of the trust who would be in charge of potentially making distributions to Peter as long as that trust is in existence. So maybe you name Fred as the trustee. And so Fred's the trustee. Fred controls distributions to Peter. Peter has no right to compel that Fred make distributions to Peter out of the Peter's trust to Peter. And since Peter has no access to the trust assets, Peter's creditors have no access to the trust assets. Now, what kind of discretion you give that trustee, that can vary under state law. For example, if you give that trustee just complete and total discretion to make distributions to the beneficiary, then that's likely more creditor protected than saying that trustee shall make distributions to Peter for Peter's health, education, maintenance, and support. Then maybe Peter could, or at least would have the authority to mandate distributions because the intent of the trust was to provide for Peter's health, education, maintenance, and support. And then it is is the trustee required to make distributions to Peter, or can the trustee in their sole discretion make distributions to Peter? So all that factors into what rights does Peter have, which eventually translate to what rights Peter's creditors would have. By the way, some of you might be thinking, well, I tell you what, I'm not going to put all that stuff in my estate plan because it sounds complicated and I don't want to impose on all these restrictions on my child so that they can't even control what they do with what I leave them. And maybe you're thinking, well, I'll just leave it to them. And then, after I leave it to them in their own name, then they can set up a trust and put it in one of these kinds of trusts that you're talking about. That doesn't work because there's far less protections when an individual transfers their own assets to a trust to try to get this creditor protection. That's called a first party trust. When, let's say, you leave $2 million to Peter in his own name, and then Peter gets that $2 million in his own name, and then he sets up a trust, the Peter Trust, and transfers his own assets that he already owns to that trust. Very little creditor protection. That's a first party trust. Far more creditor protection if you set it up so the assets go from your estate or from your living trust directly into the Peter Trust. That's what's called a third party trust, where Peter's the beneficiary, but he didn't transfer his own assets to a trust. So that's really the only way you get this kind of creditor protection, is by setting up and funding that third party trust. Okay, so what I want to hear at this point is just lawyers are in the business of promoting their services, and so in my little humble opinion, hate to even tell you this before I ask you to put this in the live chat below, but I think there's some of these creditor protection devices that do require complexity and lots of legal planning and ongoing stuff. I kind of feel like they are a little bit overhyped and a little bit oversold by the lawyers. Like that commenter told me, Paul, how many of your clients have lost everything due to there being a judgment against them? I will tell you, I've had many, many conversations with people who have been scared out of their mind because a lawsuit was filed against them. And so maybe, I remember one time a dentist called me, couldn't sleep, getting sick. He had a little bitty fender bender, but the person he hit, ranting and raving, I'm going to sue you for millions of dollars and take everything that you have, really freaks people out. But of course, it all got resolved over time by the insurance company. My dentist friend didn't have to pay a penny out of pocket. But boy, did it spook him. And people get spooked all of the time because it's just so easy for someone to file a lawsuit in America. But it's a lot harder to win on the merits and get a successful judgment against someone. But it does happen. And so want to hear in the live chat, kind of what's your thought? Especially if you're a parent with children, you're saving, you'd like to see your children benefit one day. What are your thoughts? Is this something that is a concern at all to you? Or is this something that's a concern enough that you want to put some restrictions on your child so that they don't have access to their inheritance after you die unless someone else approves it? So generally it's that balancing act. Do you just leave? And really the way I think about it, there's really, I could say there's 100 options, but I'm going to boil it down to 3 options that you've got. Number 1, just leave it to them. Is that right? Who knows? Is that wrong? Who knows? We're trying to get you to make informed decisions. But I would say in the most common, just because under the TOD, POD stuff, when people are leaving things to named beneficiaries, IRA beneficiary designations, 99% of them are just made to individuals. Lots of wills out there prepared. Probably 90+% of the wills are leaving things outright to people. Even living trusts, many of those are leaving things to the children outright. So that's one option. Leave it to them outright. Yes, that's the simple way to do it. When you leave it to your children outright, they control it. They do whatever they want to with it. But it's subject to the claims of their creditors if they have creditors. So that's one option. And I'm going to ask you in the live chat, which of the 3 options kind of just appeals to you the most? 1, leave it to them. 2, maybe leave it to them in what I call a beneficiary controlled trust. It's where it's left to them in a trust, but they're the trustee and they can make distributions to themselves out of that trust. Why would someone do that? That's, in my view, the way I think, that's more of a kind of, how do I keep my child's assets separated from other assets my child might have with a spouse, so that if my child gets divorced, they keep their beneficiary controlled trust, and then they and their spouse split the other assets that they've accumulated during the marriage. So that's option 2, is leaving it to them in a trust, but in a trust where they control it, likely subject to their creditors, but likely protected from their divorces, and not restricting them from being able to do whatever they want to do with their inheritance. So that's option 2. Option 3 is this creditor protected trust. You're putting more restrictions on them, but the plus side is if they do get successfully sued and they don't have their insurance limits don't cover the judgment, then a creditor can't seize their interest in this creditor protected trust, because your child has no access to the trust without a third party, who could be a friend, it could be a trust company, it could be someone else, would since all distributions from your child's trust must be made by a separate third party other than your child. That restricts your child's access to the trust, and as a result protects it from their creditors. So which one sounds right to you? Is it number 1, let them have it? Number 2, leave it to them in a beneficiary controlled trust in order to make it divorce proof and keep it from being commingled with other assets they have with a spouse? Or 3, leave it in a creditor protected trust and restrict your children from having access to those trust assets by naming someone else as a trustee, or what's commonly referred to as a distribution trustee. So lots of different options there on how to set it up so that your child can't make distributions to themselves. Okay, so some of you are likely going to say, in my just best guess, some of you are going to say, because most of the people, or many of the people in estate planning, sure, some of them do exactly what the lawyer tells them to do, which I think is not right. In part, a lawyer's guidance is necessary. Lawyers should, here's the pros, here's the cons, here's the pluses, here's the minuses, but want you to make that informed decision. Many people make these estate planning decisions based on their previous life experiences. I got to think some of you will say something like, Paul, I don't know, Paul, I've never been sued, and I don't know anybody that this has happened to, and I don't want to put all these restrictions on my kids, so I'm just gonna let them have it. Or some of you might say, yeah, I don't want to keep my child from being able to access their inheritance. I don't want somebody else involved telling my children when they can spend their inheritance. But I do like the idea of setting it up for them in a way that it's protected from their divorce. So some people are going to say that. And then I think some people, based on life experiences, maybe because you've been sued, or you've seen people lose everything, or you just know we live in a litigious society and you want to give your children as much protection as you can. Some of you will say, yeah, I'd like to arrange my estate so that when I pass away and leave things to my children or whoever, that creditor protection is one of the most important things I want to make sure happens. So it's a personal preference thing. Make an informed decision. That's what's most important. All right, let's jump over here to the chat and see what we've got going on. By the way, feel free to like and subscribe. Sometimes our chatters even getting into the habit of reminding all of you to like and subscribe. So if you're live, fantastic. Go ahead and hit the like button. If you're watching on a recording, either you can, of course, you can always like and subscribe, but you can put what your thoughts are in the comments because you won't be able to participate in the live chat. All right, so let's see. We've already said hello to a bunch of folks. Would this protect them in case of divorce? It can. Loving life. So yes, if that child is not having a loving life and gets divorced, then, and yes, set up the right way. You leave assets in trust for your child. Essentially, the kind of number one goal here is making sure those trust assets don't get commingled with other assets your child may have with a spouse. So if you are beneficiary belonging of loved one, is it better to go with a living trust with annuity and bank account? If you are beneficiary belong, God, Marlene, I can't really. May want to rephrase that. And wondering about long-term trustee and how to instruct them since heir will outlive most friends. Yeah, great point. So loving life. Lots of talk about, okay, do you, if you want to protect it from your children's creditors, do you name that friend as the trustee or co-trustee or distribution trustee? Do you give your child the right to change who that trustee is, as long as your child and certain other people that they control are never a trustee or a distribution trustee? You're right. Your children could inherit when they're 45 or 50 years old and could live another 40 or 50 years. And so in order to keep that trust in existence and operating for the remainder of your child's lifetime, yes, there has to be provisions in that trust addressing what happens in the event of a vacancy in the office of a trustee or a distribution trustee. So good question there, loving life. Good evening, Nafiz Watkins, Donald Parrish. I'll leave it unless worried. Yeah. So excellent. You guys get me thinking about some things. So Donald, some parents will come to me and they'll be like, Paul, my child, he's in a risky business, or he has the type of profession where lawsuits are commonplace, whatever that profession might be, or my son has signed and personally guaranteed for his business or for his child hundreds of thousands or millions of dollars of debt. That increases the likelihood that there's going to be some kind of creditor problem one day for the child. So that should support Donald's point if you're worried about it, because you see a potential problem down the road, either with a child's spouse or with a child's creditors or with the child's activities or what some of the things the child has obligated themselves to do. Then that could tip the scales to make you do something like that. Beneficiary control trust. I like that too, Newell. I hate to kind of pour too much of what my own desire is, but I like that too. Divorce is so commonplace, 40, 50%, whatever the rate is. And so by leaving it to a beneficiary controlled trust, especially if your children are adults and responsible and you just don't want to restrict them. Kind of feels like you're penalizing them a little bit if you're restricting them from even being able to access what you're trying to leave them. So I'm with you there, Newell C. Hall. Option 2, yep. Joanne, same thing. Joanne, with number 3, is you're going to need to declare bankruptcy authority his creditors and then get his inheritance. Yeah, that's a bankruptcy question. I'm not a bankruptcy lawyer. That's a question better posed to the bankruptcy lawyer. So I'm just going to pass on that, Joanne. And Larry, in California, inherited property is not considered community property. I want to start my kids to open separate accounts and never commingle any funds through it. Yep. So in most states, inherited property is not community. Well, it's certainly not in community property states, of which there's 9. It's not considered marital or joint property. So yes, even if the child inherits outright, as long as the child never commingles, never mixes up the inherited assets with assets that they have with their spouse, should be okay. I know in some states the income produced by separate property is community property. So sometimes I've seen problems where someone inherited $1 million, parked it in an account in their own name, and then that $1 million account, whether it was CDs or stocks, bonds, mutual funds that produced dividends and interest, in some states that income that the separate property produces, the income is community property, and then the community and separate get mixed, and we got a problem. So just be aware that could be an issue as well. It depends on your state and what your state rules are. All right, and Hong, I'm glad you learned a lot today, and I love your emojis. Most of you, if you've been heard me before, I like emojis, and Hong and Bowie's got some good ones, and I probably just butchered your name. All right, we've got we've got some big ones coming up here in the next few days. Hoping you can make some informed decisions. We'll see you next time.